And if you're in your heart, you ask
Stop.
if it's the truth,
Stop
you'd say that's
pointing at
true.
me.
You know that's true.
Stop shouting at me.
I'm sorry. I'm a little bit heated, I
No, you're
apologize.
completely and totally out of control. It's not
No.
heated, it is completely and totally out of control.
Please come to order. Court is now back in session. Yes, ma'am. Thank you, everyone. Please be seated.
Does the state stipulate to the presence of the jury panel
We do, Your Honor.
and the defense?
Yes.
Mr. Bateman, you may address the jury. Closing argument.
What a week. Quixotic. Remember that word? Remember what it means? Foolishly impractical in the pursuit of ideals. Okay? Does that sound like anyone you know? Okay, again, going back to Don Quixote, statement in him. People thought he was eccentric, they thought he was odd, not only for trying to bring back chivalry and honor to Spain, but probably more so for the way he went about it. Jousting at windmills, doing all the sort of things that just didn't seem to make sense to anybody. But I told you my opening statement, despite all of Don Quixote's shortcomings, he never lacked sincerity in his quest, ever. Okay, and similarly, Mr. Blandino's actions might make you think he's eccentric and odd or just plain foolish, whatever. And that's fine. You are entitled to have your own personal opinion about him. And maybe now, hopefully, makes a little more sense if you remember last week during jury selection, right? I asked you, are you able to separate your personal feelings for Kim Blandino and only look at the facts? When I asked you on a what do you call it, on a sliding scale, right? From like 0 to 10, right? 10 being, yes, absolutely, I can totally do that, right? I can totally separate any personal negative feelings that I might have for Kim Blandino and only look at the facts. Well, now is the time to prove that you can separate any negative feelings that you might have for Mr. Blandino and only look at the facts here, right? What did Kim Blandino really want? You'll see that through all his correspondence, all his letters, everything, all he wanted was just to sit down and talk things over to see if there's common ground. You remember Detective Meade said that's not illegal to ask to meet with someone, right? They called him, right, on April 29th. They called him and asked him if he wanted the judge to reverse a ruling, right, or take away contempt time. He said, no way, that's illegal. If you'll recall, when he was testifying, he said that he suggested that, and I said, you might want to talk to an attorney, that's illegal. And there's almost a childlike innocence in that, okay? You know, he didn't know that the cops were listening in, that they were trying to set him up. He wanted to meet. They didn't want to meet him, but they couldn't be honest about it. They led him to believe that they would talk with him, deal fairly with him. Remember, this is the guy who takes everything literally. Okay? You saw him sprint to the water fountain because he thought he had 10 seconds. I personally chuckled the first time I saw it because I didn't really think he meant 10 seconds literally. Okay? But you can tell Mr. Blandino is very literal. And the sort of consistency in his literalness is no act. You heard it on, you know, they kind of said, well, he can't really answer a straight question. But it, for example, like, well, you went to his private office. Well, no, His private office is like where his desk and computer is. I went to the reception area of the main office, right? Or the docket or the register of actions. It's titled Register of Action. It's what Mr. Dickerson referred to the document. Or the letter when you said, no, I wrote. He's very literal. And we saw many examples of that, of him being very literal. So that's the guy that they're leading to believe that they'll talk to him, that they'll deal with him, right? It's sort of kind of the ticket in, right, is to send me something specific, right? He had no idea really what he wanted, okay? And you can tell, really, he didn't want anything for himself, like nothing, absolutely nothing, for his own benefit, right? Take a class, Mr. Federico, that's for your benefit, it's not for Kim. Donate $500 to the Clark County Law Library, it doesn't benefit Mr. Blandino, okay? Now they're trying to hang their hat here, on the $25 he asked for, but it's very clear in the documents that money is to reimburse the person who loaned Kim Blandino the $25. And, an apology in writing, what's that word? Right, remember, he still thinks this is some kind of legitimate kind of discussion or negotiation or whatever you want to call it with Mr. Federico. And he alluded, and Mr. Federico, so he thinks this is like, I'm sure he thinks, he's out of his league, he's dealing with, with attorney. Mr. Federico alluded to the fact, negotiation tactic, you ask for more than what you want to really get what you want. And so we're supposed to believe that the guy who had to borrow $25 to get the court video isn't asking the big shot lawyer who works at the big prestigious big shot law firm for any money for himself, right? Do you see the sincerity of purpose in that? He's Don Quixote. He's bringing chivalry back to Spain. He's trying to make sure that things are better in the future with his requests. That's all. He testified to that. Now, in their opening and their closing, the government said that this was about the rule of law, right? And that Kim is a dangerous threat to that very rule of law. And I don't really see it that way, okay? What I see is about kind of the powerful and the powerless. Yeah, he wanted to affect change, right? And really the only threat to the rule of law is about the abuse of power. I mean, anyone can file a complaint with the Nevada Commission on Judicial Discipline. And because Mr. Blandino can do that, he's certainly within his right. We've established that. And he's within his right to go and ask to see if Mr. Federico would meet with him. But his efforts are met with disdain and contempt, right? He's really asking for an opportunity to be heard, but it's just like, what does he get? He gets attitudes like, who's this guy? Who are you to come here and want to talk to me? And it's not in any way improper for him to talk to or want to sit down and talk to him. If you recall, about the phone call on April 29th, over and over repeatedly, he said he just wanted to meet. He wanted to meet. Mr. Federico said, yeah, he kept saying he wanted to meet me. He wanted to just to talk, right? You recall, he went in there April 8th because he said the Holy Spirit directed him to. He went there with no agenda, no list of demands, nothing. The guy you see here bringing 5 banker's boxes full of stuff and looking at, and I had to borrow a piece of paper to write a note. He had no agenda, no intention to extort anything. Okay? And you have your jury instructions, and you have instruction on reasonable doubt and the burden of proof, right? The burden of proof is here on the government's shoulders. That's prove every element of every crime charged beyond a reasonable doubt, okay? They can't prove most of the elements beyond a reasonable doubt, and it's like, okay, that's close enough. No, it has to be every single element. And the failure to prove any one of these elements beyond a reasonable doubt, has to result in a verdict of not guilty for that crime. And that's our system here. This is the way our rule of law and our judicial system is set up. Okay? It never imposes on Mr. Blandino or any defendant, okay, the burden of proving anything. And that is our system. So by law, our defendant starts out to say this is innocent here, right? Guilty here. He doesn't start out anywhere in the middle. He starts out with the presumption of innocence. And it's a hefty burden to get him all the way to a guilty verdict. And anything short of that has to result in a not guilty verdict, even if you don't like him. You don't have to like him. Not that you need my permission, but you have my permission to not like Mr. Blandino. Okay? And there's one of those things in the jury instructions that states that every crime there has to be a union of act and intention, okay? And one of the essential ingredients, of the crime of extortion, okay, is the intent to extort money, or gain property, or accomplish any of the other things listed in the law, okay, by any of those other means listed. So you got to try to accomplish something by the means listed in the statute there. And the intent to do that is really what's at issue here. You see, extortion is a type of theft, really. Okay, it's a theft crime. You can be a thief by robbing someone at gunpoint, shoplifting, pickpocketing. Those are all thefts, but by different means here. We used to call this crime blackmail. Okay, it's the means by which the theft, whatever, is committed. And so this case really hinges on Mr. Blandino's intent. Okay, did he really mean to extort anything of value? Okay, no. Okay, he didn't seek any money or any gain for himself. $25 is going to someone else. $500 is going to the public law library just down the street here. Okay, the class is to help Mr. Federico. This is all to make the world a better place in the future. An apology? What's that work? Try depositing that in the bank. Or next month, April 15th, they said talking about paying your taxes. I believe they did on closing. Try paying your taxes with apologies you've received in taxable year 2021. Okay? The other portion, influencing the actions of a public officer. No, he didn't do that. They tried on that phone call. They said, hey, do you want me to take away the contempt time? Do you want me to vacate your fines? Right? It was something to that effect. Everyone that testified, 4 people testified as to that phone call. All of them consistently said, we asked him, do you want me to do basically something illegal, which is undo one of my words? Every single one of them said no. He did not want that. He had no intention of doing anything illegal. Okay? And he said that. He said no. They offered him, do you want this? He said no. That's illegal. I don't want you to take away the contempt. Okay? He's got a beef with Mr. Federico. He would probably love that. But that's illegal. He said no. He said no even without even knowing that 2 law enforcement officers were eavesdropping on that phone call. All right? And what he was asking for wasn't illegal. He wasn't asking Mr. Federico to do anything in his capacity as a judge, like reverse a ruling, like lift a contempt order, vacate a fine assessment. Now, I know that the letters are addressed to him as a judge pro tem, but that's his title. Okay? Or certainly one of his titles, and he's showing him that respect. This is, in his mind, some type of legal negotiation, and he doesn't know Federico is lying to him and working with the cops. He has no, because he's not intending to extort anything. Kim Blandino is not intending to extort anything. He has the right to file a complaint with the Nevada Commission on Judicial Discipline. Mr. Dyla even said so right here in the courtroom. So if he has a right to file a complaint, he also, you heard Detective Meade, he has a right to try and seek a meeting with Mr. Federico. And that's what he tried to do, okay? His appeal had just ended, okay, in March. And while that appeal's pending, it probably is improper to talk to Mr. Federico about it while the appeal is pending, especially if it might get reversed. Okay? It's, for example, it's improper for any of the jurors to talk to the judge or anything. Once the trial is over, that restriction's gone, and you're free to try and talk to any one of us. But not until that time, right? Well, he waited until his appeal was over, and then, again, he went to Mr. Federico's office. Okay? Sitting down and talking was all he ever wanted to do. Okay, when this started on April 8th, like I said, he went to that law office because he felt that the Holy Spirit had directed him to do that. And, he's a deeply religious man. You probably could see that in some of his answers. And so he went there with nothing. The guy you see, with anchors boxes full of stuff, he just wants to try and meet with him. Like, really, that's all. He's just trying to talk to him. See, read that, and read that May 16th letter that he sends to the partners, and see how many times he asks for a sit-down meeting. It's at least 3 times. He just, I believe, I want to sit down. That was really his only intention from the outset, is to sit down and talk to him. Okay? And it's not illegal to ask for that sit-down meeting. And really, this is a classic illustration of making a mountain out of a molehill. And his intent, again, is important because it's an element of the crime of extortion. And you'll have your jury instructions, and it says it starts a person who, with the intent to extort or gain any money or property. He had no intention. Okay? In his mind, he's trying to just talk to him. So, hopefully, look, I'll say this. We talked about, Mr. Federico, sort of the art of negotiation, because he thinks when he talks to him, Mr. Federico, if you recall, was just like, I didn't like it that, he was getting one over on me, and just that sort of, the contempt that he sort of had for this process. But he led him to believe that he would, okay, give me something, in writing, okay? When all he was asking for on that phone call was to sit down. So they changed it. Through the police, they changed it. They said, no. First they asked him, hey, don't you want us to, us. It was really only Mr. Federico was on the call. Don't you want me to do this? Who's suggesting the crime here? Who's inducing it? Who's suggesting it? Who started that? His letter was to meet, was to talk. Again, he has every right to file that complaint, and he has every right to want to try and sit down and talk to Mr. Federico, even prior to filing, so that maybe his complaint is accurate. Maybe there's like, oh, okay, I can see that, and excludes that from the complaint. Mr. Federico obviously has no obligation to talk to him, but he didn't tell him, no, I'm not going to talk to you. And Mr. Federico, that's all Mr. Blandino, he sent these letters before, and that's all anyone ever says. Now, I'm not gonna talk to you. And
Seems facts not evidence, Your Honor.
And the jury will determine what the evidence is.
thank you. So, he testified. No one had ever responded to him, ever. And that jury instruction number 13 talks about intent, okay? The specific intent needed for the crime. So be sure to review that and think about that here in the context of what he's asking for. What does he really, really want? He never asked for any money for himself. In the writing that they asked for, it was clear the money was that $25 was to go to someone else. He never asked Mr. Federico to do any official act as a judge. Okay? A public apology is not an official judicial act. And judicial act, one of these official acts is it's along the lines of the illegality that they proposed to him on the phone call, right? When they spoke to him, when they were trying to entrap him, right? When they were trying to induce him to say, yes, yeah, that's a great idea, right? Those elements, was his willingness? No, he wasn't willing to commit that crime, right? Now the government is going to say, hey, that letter of May 9th, that he said, Mr. Federico, and the May 16th letter that he sends to the partners of Olson, Cannon, et cetera, and everybody. But look closely at that letter of the May, I guess it's dated May 8th, so on May 9th, that he sends in the request for a global negotiation. Okay? What may appear to you as just sort of a rambling stream of consciousness is really revealing in his intent. And his intent really is not to extort, is to try and resolve a dispute. And I want you to look at that if I may. Okay, this letter, May 8th. This is Exhibit 7. You'll have it. Right here. It says, I do appreciate your phone call to me, at least to reach out and settle matters. I have been consistent in all my dealings to attempt to settle matters of dispute in all areas of my life and dealings, even when I have been at a Home Depot or retail or other retail establishment and have been treated badly by an employee. In that very moment, I ask the person for an apology. About 99% of the time, the matter is resolved then and there. With some, the person refused, and then I escalated the matter to the manager on duty to make a formal complaint. Okay, again, that might seem like some sort of rambling stream of consciousness, but it does show his intent. His intent is not any kind of extortion. It's to resolve a dispute, right? See, at this point, he doesn't know that he's being played for a chump by Federico and the police. He's a quite principled and consistent man. So in that letter, right, he says that when he seeks to reconcile, if he doesn't satisfaction, he goes up the ladder, so to speak. Right? My 12-year-old would call this action being a Karen. Right? maybe heard that term. It's not illegal to be a Karen. Okay? Mr. Blandino thinks he's dealing with someone who is sincere in trying to work things out with him. And remember how literally he takes everything. Okay? The first proposal didn't try and extort anything. They couldn't, they didn't arrest him for it. And he doesn't hear anything back from Mr. Federico. Like, nope, not going to do, he doesn't say, no, I'm not doing that. I'm not doing any of that, right? No counter proposal, nothing. Like he said he would. So, yeah, he's telling the partners, hey, be aware of the situation that's going on with one of your attorneys. He's being a Karen, right? That's what he's doing. Now, in the May 16th letter that he sends to the partners, and you'll have that, this is Exhibit 8. But he doesn't, oops, he's not. This letter, it's a little awkward. There's that sort of lame attempt at comedy in this letter. It doesn't mention any crime at all. He's not threatening anything. He's just letting them know that he was contemplating filing a complaint with the commission, as is his right. And it's a good time to remember that you heard from Paul Dialet. These complaints are confidential. They're not released to the public. Right? Only the most egregious cases get there. But, like in the 4th paragraph, he says, I think it's one of the reasons to have a sit-down conference. Okay? I'm here, on the second page. I'm very flexible and willing to meet almost any time and any place with Mr. Federico. Okay? The last paragraph. I would hope Mr. Federico has the courage to do a sit-down. What he wants is to sit down and talk and be heard. They changed it, said, no, you have to give us something right. You have to tell us, you have to make this more than it is. That's your ticket in. Otherwise, I'm not going to engage. We're not gonna give you the time of day, right? Because again, he's a nobody. He's a nobody who everyone ignores. He's been doing this for years and has been ignored for years. Right, let's talk about the impersonation of an officer. It's really sort of piling on. You heard testimony. Investigator for the Nevada Commission on Judicial Discipline doesn't really exist. You heard Mr. Dialet say they don't have investigators on the payroll of the commission. And any official investigation is done by independent contractors. But that's not until there's a long, drawn-out process, this tortured process of the complaint comes in and they review it, and then has to go to the 7 commissioners there, and they decide to act. And so it takes a long process before it gets there. And Mr. Federico knows this. He's been a judge for over 2 decades. He's been an attorney for over, 26 years, I believe?
That assumes facts, not evidence, as well as far as what Mr. Federico knows about this.
It's sustained.
So, there's a long, drawn-out torture process, right? Now, the government asked Mr. Dialet that when the commission brings these investigators on board, they become public officers. He said, I believe so, yes. Well, his belief is insufficient to meet beyond a reasonable doubt. The government will say, well, I can subpoena people, do all these things that they said on their closing. And that's just what Mr. Dialet explained. That's what they asked him right before that. And they asked, so they become public officers, right? And that's what he said, I believe so, yes. The closing argument here isn't evidence. Opening argument wasn't evidence. Only the exhibits admitted into evidence and the testimony of the witnesses here can be considered as evidence. And I submit to you, haven't heard definitive evidence that investigators for the commission are public officials. The belief isn't strong enough to meet the standard of beyond a reasonable doubt. And if that's the case, every element of every crime has to be beyond a reasonable doubt. You have to render a not guilty verdict. And regardless of that, let's say you think in your mind that they are private individuals, okay, with special authority. Kim never held himself out as such. In all his letters to Mr. Federico, why does he use the modifiers volunteer and unpaid? Especially if he's intending to defraud someone, to fool someone, right? It's a reasonable inference to draw that he's unofficial when he says that. But we get like willful denials from the witnesses on the government side. No, the words unpaid and volunteer would never mean unofficial or, come on. It's unreasonable not to even entertain the thought that those words could mean unofficial, right? If you're really trying to impersonate someone, why say that? Why not just say, I'm an investigator with the commission? See, one of the elements of the impersonation charge is defrauding or injuring someone. Okay. Marshall Marwitz I think you called him an investigator journalist, if I recall. That's not any public office. But he was never defrauded or duped into thinking that Kim was somehow officially with the commission. And regardless of whether he wasn't, if he wasn't fooled because Kim meant unofficial by saying unpaid, volunteer, he knew he wasn't connected. Come on. He wasn't injured. Mr. Federico, likewise, was never defrauded or injured by anything. He didn't lose his job. He's still a judge. Okay? Again, these modifying adjectives, unpaid, volunteer, mean unofficial. There's no intent to deceive anyone. In fact, it's demonstrative, really, of his intention to be honest about who he is. And I know Mr. Federico suggested, well, maybe he thought that Blandino was perhaps a rogue agent. Please. That doesn't really even pass the straight face test. You saw Mr. Federico first met Blandino in 2018 at that traffic trial. You watched the whole encounter twice. And while watching that at any time, did you think, hey, maybe this guy could be a rogue agent? It just, like I said, doesn't really pass the straight face test. Okay, you have that in jury instruction 14 about what constitutes impersonation of a public officer. Okay, there has to be injury or defraudation. We don't have that here. And, okay, even if you are satisfied, beyond a reasonable doubt that each and every element of extortion was proven, there is the defense of entrapment. That's like an exception to being guilty. He was entrapped by the police acting through their agent, Michael Federico. You have the jury instruction on entrapment. It's jury instruction 25. Okay. Entrapment consists of two elements. First, there's the opportunity to commit the crime. Okay, it's called inducement, that the opportunity to commit the crime is presented by the state. And then second, the individual was not predisposed or willing to commit this crime prior to it being presented by the state. This is, and the state went over this, right? Some of the factors here. Now, this isn't an exhaustive list, okay? Character of the defendant, Sure, he's a character. But who first suggested the criminal activity? Okay? I'll submit to you, the police did. Through Michael Federico, said, hey, do you want us to do this illegal thing? Do you want us to, I keep saying us. I know really the phone call was from Federico, but they're all acting together. They're the ones that suggested it. You heard Detective Mead say, it's not illegal to go and ask to meet with someone. That'd be foolish. You don't really go to a big fancy law firm unannounced with no appointment and say, can I do that? Can I see so-and-so? Okay? 3, whether the defendant engaged in the activity for profit. No. He didn't gain anything. He didn't ask for any personal gain for himself. Okay? $25 was reimbursement. There's a hold harmless clause, right? Mr. Federico discussed that. So Mr. Federico pays the $25 to Mr. Blandino. Mr. Blandino then gives it to the person who loaned him the money. Well, that person, the loan of the money, can't go after Mr. Federico for that money because he's being held harmless. It shows he did not engage in any of these things for profit. That money clearly is not for him. $500 is for the Clark County Law Library. The class is for Mr. Federico's benefit. He clearly can tell. He doesn't think Mr. Federico, doesn't think much of him as a judge. Okay? And whether the defendant demonstrated or what? He said no. All of them. All 4 people on that phone call, all were consistent, saying when we offered him a crime or for him to agree to it, he said no. Right? Adopted Nancy Reagan's philosophy, right? Just say no. He said no. And they were trying to entrap him. Okay? His intention was always trying to meet face to face and try and talk things out. He goes to a lawyer's office unannounced, without an appointment, to see if he had time to talk to him. He said, it's kind of foolish. It's not illegal. Again, Detective Mead said that. He had nothing prepared when he went. He truly went there with no agenda, just to try and talk to him. On the letter at the bottom, it says, I came here personally as a good faith gesture. Right? That's how he closes out that letter. Then the other elements come into play. The opportunity to commit the crime is presented, right? So they're going to say, well, he went to the office twice, so everything started with him. The second letter on April 25th, he just wanted to meet, albeit with a new grievance for being kicked out of the courtroom. But that last paragraph on the April 25th letter begins, we should meet and see if these matters be settled. I mean, is that, is that so terrible? He just wants to say, hey, can we talk about this? Can we work, Can we just come to some agreement? But no. They said, no, we're not going to meet. Give us something we want. Give us something in writing, right? Why? So there could be a paper trail, so they could arrest him. They played him for a fool. They teased him, right? And led him on to think that they would negotiate with him fairly and in good faith, when really and truly nothing was further from the truth. Now, to show his character, he does this all the time, right? Oh, he does this all the time. He sends these letters. Well, nothing ever come of them. You heard it. There's never any response. So finally he said, well, give us something in writing. And he talks about it. Hey, I've never done this before. Right? He's never, like a settlement. Like, so he cuts and copies and pastes the document. Again, he never created any such document before. They said, oh, no, he's got this pattern, this long history of doing this. No, when they said, hey, give us something in writing trying to trap him, he's like, oh, okay, I'm, you know, kind of out of his league. He doesn't, he's never done that before. Okay? Oh, I want you to think he's so scary, right? There's a survivability clause in there. He must be threatening Mr. Federico. You heard Detective Meade talk about they found nothing threatening or anything illegal in his house after they executed the search warrant. Okay? He's not a threatening person. They would have, I'm sure, they would have found something. They would have acted on it. Okay? They didn't arrest him after he sent that first proposal because he wasn't suggesting anything illegal. He wasn't predisposed. Okay, so even after they said, okay, give me the writing, he's still not proposing anything that they act on because it's not good enough. He's not predisposed to commit extortion. So they ask him for another one, right? Another email saying, hey, give us a global settlement. Why? Because they're probably still hoping that he would ask Mr. Federico, because they wanted to include that August 2018 trial. They're hoping, hey, undo that contempt. They're still trying to grasp at him requesting something illegal. But our quixotic friend here is not trying to enrich himself. There was never any criminal intent on his part. And absent a written document that the police requested, there would be no grounds for arrest and no criminal charges filed. So, you know, he is, like I say, a nobody. I don't mean that in a mean sense. But he's a nobody trying to hold the somebodies accountable. Right? I mean, a nameplate on the thing, it's not the end of the world. But yeah, we have, you know, we discussed it. Our courtrooms are open. They're open to the public. And you know, judges should be readily identified. You know, who is this person who's standing in judgment? We give judges a lot of power. And we should expect a lot. Okay? You know, he's trying to hold somebody's accountable, but he gets contempt. Like, who are you? Who do you think you are? He is as sincere as our friend Don Quixote. His methods, yeah, are probably not what you or I would do if we were trying to accomplish the same things. Okay? The rule of law is meant to protect the powerless from the powerful and hold them to account. Okay? The rule of law will survive Kim Blandino, but the rule of law will not survive the abuse of power against the powerless. So as you go back to deliberate, I'm asking you to please think about, what did he want? Look at those documents. All throughout there, he just wants an opportunity to be heard. He just wants to talk to him. He was the only one who ever gave him the time of day. And where there is no intent to extort, you must render a verdict of not guilty. There's no intent to impersonate a public officer. No one was defrauded. No one was injured. So I'd ask you, when you deliberate, to consider those facts. And I think once you do, you will come back with a not guilty verdict. And I appreciate you and your time and your patience. And remember, what was your number? If it was a 10, get a 10. Separate all your feelings, your negative feelings, and just look at the facts. I asked you on my opening. Think about this throughout this whole trial. I didn't think it would last this long. Gotta be honest. What did Kim Blandino want? You want him, you heard him. He wanted nothing for himself. He wanted to make the world a better place, doing his part as really a relatively nobody.
Thank you.
Speaking from rebuttal? Can you give her a microphone?
This isn't to make the world a better place.
Hang on.
This, so Kim Blandino can have fun. This is what he does for fun. You heard him himself. If you aren't having fun, you aren't doing it right. That's exactly what this is about. He told you he was having fun up here today, up here yesterday. He was having fun doing all of this because, as he told you, this is what he does. He goes, he targets judges for investigation, and then that's what's fun to him. He set up his office in his house where this is what he does, his illegal work, as he called it. This is not a matter of some man that's foolishly set off on some random journey against one judge. By his own words, what you've heard is what his course of conduct is and has been for years. He told you that, yeah, he sent these letters to other judges. Despite what defense counsel says, it's not true that he's never gotten a response. He told you himself that he got a response by marshals coming to his house. He knows what he was doing is wrong. He's not just Don Quixote. He's not even close to Don Quixote. He is a man who is obsessed with this cause. He is obsessed with this because this is his only form of enjoyment. This is what he enjoys most in life, is seeking these sort of interactions to see what kind of play he can get. If he can get somebody. Here, he thought he did. This, Mr. Blandino, if you aren't having fun, you aren't doing it right, that goes to his motive. You're instructed on motive. It's instruction 4. We're not required to prove motive, but it's something that you can consider. Motive is what prompts somebody to act. So, well, Mr. Blandino told you he doesn't really want much for money or anything like that. He doesn't really care about that, right? What he cares about is just going along this path and enjoying himself where he doesn't. That is what he's accomplished here. That's what he's doing in every single letter. You can see it in his letters as he writes and he puts in these jokes that fall flat. This is him having fun, and that's why we're here. Because Mr. Blandino has decided that this is how he's decided he wants to have fun, is by going after judges, sending them inappropriate correspondence, having inappropriate contacts with them in an attempt to see if he can influence their actions, the actions of public officers. Jury instruction number 12. That's the definition of extortion. A person who, with the intent to extort or gain any money or other property. You're instructed as to what extort means. Extort is defined in jury instruction number 12. Extort means influencing another person's actions through withholding a disclosure of information. That's exactly what he was doing. He was influencing or seeking to influence. He had the intent to influence Mr. Federico's actions in his capacity as a pro tem judge. And he also, because this is an or, right, sought to gain money. Well, the money was not a large amount, right? $25 in his own pocket. Two different ways here that Mr. Blandino has met that first subsection of the first element of extortion, both by withholding information, right, and influencing action, as well as to gain money. $25, it can be 50 cents, it can be $2 million. It doesn't matter. It's going in his pocket, and that's what it is. It's going to him. And I'll just note, because defense counsel argued a lot that, well, this was going to repay somebody and the money's going here and there. It does not matter. That is not an element of the crime. It doesn't matter where the money was going. He said, you need to pay me $25. It doesn't matter what he was going to do with it afterwards. And then, across the whole thing, the next way that you get his intent is Mr. Blandino's intent to influence the actions of a public officer. I'll note for you that throughout every piece of correspondence that Mr. Blandino provided to Mr. Federico, it was addressing Mr. Federico in his capacity as a judge pro tem, in his official capacity. It begins right here. Exhibit 3, the note that he wrote on April 8th to Michael Federico, pro tem judge, alternate judge, City of Las Vegas. April 25th, 2019, Michael Federico, in his capacity as a judge pro tempore. When he finally tells him exactly what he wants, Michael Federico, alternate judge for Department 20, Courtroom 1C, Las Vegas Municipal Court, at the Regional Justice Center. The May 9th letter that he dated because he'd been working on it for several days, May 8th, Michael Federico, in his capacity as a judge pro tempore. All of it, ladies and gentlemen, was directed at Mr. Federico in his capacity as a judge pro tempore, because everything that he sought to do was influence Mr. Federico's actions as a judge pro tempore, as a public officer. None of it is appropriate. It's illegal. That's the bottom line. Even if you buy what defense is saying, that he just wanted to sit down, though we'll go into that, and his own words belie that. If he says, Mr. Federico, I'm going to file complaints against you unless you sit down and talk to me, that's extortion, right? That is extortion. Defense went on and on about, Detective Mead said, yeah, you can ask to meet with anybody. Yeah, sure. You can say, hey, look, I want to talk to you, I want to meet. But you cannot threaten somebody to do anything. This is not, as defense counsel said, a form of theft, as much as it is a form of coercion. This is a way that what the law has done here is made it illegal for people to say, I want you to do something, or else I'm going to do this other thing that you really don't want me to do. Because here, in this case, those things, imputing disgrace upon Michael Federico by filing a complaint with the Nevada Commission on Judicial Discipline, by sending all these things, these horrible allegations to his bosses, all of that, by filing criminal charges with the FBI, all of those impute disgrace. And that brings us to exactly what the threat was. Here he threatened, Mr. Blandino threatened to accuse Mr. Federico of a crime, namely a federal civil rights crime, and accusing him of that to the FBI, as well as to expose him to disgrace. Disgrace in being what he believed is an unethical judge who's violated the code and violated his rights, knowing, as his own words stated within the letter from May 9th, knowing exactly what this means. Look at that. Mr. Blandino says, when in the very few times that he actually speaks in the first person, I would want to know that a person who worked with the firm that had a prominent web page was not bringing any disrepute in any way to the firm or its name. Mr. Blandino knows that that's what he's threatening, knows that's his whole intent here. To expose or impute disgrace upon Mr. Federico. You're instructed Jury instruction number 21. Disgrace means to humiliate or cause loss of favor or standing. You heard from Mr. Federico what the effects of these actions could be and would be, and it was humiliating and could cause loss of standing and favor. In fact, when Mr. Blandino starts ramping up his behavior, right, when he doesn't get the response that he wants, and I'm not talking about the first response or the second response, I'm talking about the response on May 15th, 2019. After that letter that he sent on May 9th, 2019, when he doesn't get a response back from Mr. Federico, and he ramps it up to the next level, he makes good on his threat. He makes good on his threat to expose Mr. Federico to disgrace by actually sending everything that he already sent to the managing board of directors of his firm, all of his bosses. And what did Mr. Federico tell you about that? It was humiliating. It was humiliating. That's it. Mr. Blandino has committed extortion so many different ways in this case. Not just one. There's not just one avenue of extortion here. It begins with Mr. Blandino. It begins right there in the note that he wrote on April 8th, 2019. I am ready to begin filing my complaints against you, indicating that it's for his courtroom activities, including violations of the code. He indicates that he's required by his religious beliefs and practices to give him an opportunity to negotiate a settlement. Please let me know within the next 10 days, indicating how serious he is, because he's been effective. He's been effective because his last two letters have resulted in letters of caution. So please, don't take this matter lightly. This note doesn't say, hey, I just want to sit down and I want an apology, Mr. Federico. It doesn't say that. It doesn't say, hey, I'm going to file a complaint against you regardless, but I'd love an apology. It doesn't say that. What it says is I'm going to file a complaint, or we can negotiate. Extortion begins there. Then, when he doesn't hear anything from Mr. Federico, he goes to the Regional Justice Center. He told you that he was all around that day. He was all around. Yet somehow, he walks into the courtroom still carrying his tray of stuff with his shoes untied from walking through security. And he told you that before he ever got into that courtroom, he looked right into it and he could see Mr. Federico right there on the bench. Okay. Now, he goes in, he sits down, he gets kicked out. Mr. Federico, in no unclear terms, in his capacity as a judge in that moment, says, you need to leave because you came to my private law office. Don't stalk me. Defense and the defendant himself told you, if only he had said, just don't come back, I don't want to talk to you, that's it, nothing like that, then that would have been it. There are no clear terms. Get out of the courtroom, don't stalk people? But what does Mr. Blandino do? Well, now he's getting the reaction he wants. Now, Mr. Blandino is having fun. And if you aren't having fun, you aren't doing it right. So now, Mr. Blandino knows he's on the right path. The path that he has set forth upon to see what he can get out of Mr. Federico. So he goes, he files a customer feedback complaint for whatever that's worth, and takes that and attaches it to a letter that he went home immediately and typed. April 25th, 2019, this letter. This is the letter that, once again, to Michael Federico in his official capacity as a judge pro tempore, as we discussed. The subject line itself indicates what's occurring here. The subject line itself indicates, I mean, it might as well say, subject, extortion. Desire not to have to file formal complaint with Nevada Commission on Judicial Discipline. That's not how this works. If a judge is does something unethical, they should just be reported. They should be reported. Anybody that's doing something unethical should just be reported. You, or Mr. Blandino, I should say, as a private citizen, anybody in this country doesn't have a right to dangle something over someone's head to say, you were unethical, now I own you? You committed a crime, now you have to do what I say? That is extortion. That is the purpose of this crime. And in this particular letter, Mr. Blandino discusses thoroughly what he'd initially started talking about. In addition to identifying himself as a volunteer investigator for the Nevada Commission on Judicial Discipline, not helping the Nevada Commission on Judicial Discipline, he is for the Nevada Commission on Judicial Discipline, indicating, I came to your offices to see if we could resolve the complaint without having to use scarce judicial and Nevada Commission on Judicial Discipline resources. He indicates that he's done so with other misbehaving judges. And then he goes on, so to avoid having the Nevada Commission on Judicial Discipline subject the complaint to their protocols, I once again reach out to you to resolve this matter between you and I, or your attorney and I, if you wish to have an intermediary. You remember that whole argument defense counsel had about all Mr. Blandino wanting to do was to sit down with Mr. Federico? April 25th, 2019, he's telling Mr. Federico he doesn't even have to deal with him directly. He can have an intermediary. This whole sit-down thing, it's not even a real thing. Because you take a look at Mr. Blandino's words, he didn't care. He wants to see what he can get out of Mr. Federico, whether it's Mr. Federico dealing with him directly or Mr. Federico's intermediary. And then, please know that I am very serious about following through to the best of strength that God gives me to do so. He indicates the sacrifice that I spend in time, inconvenience, and discomfort is very small compared to what they suffer to establish freedom and liberty based upon the very principles that God and His Son Jesus would wish for all on this planet to enjoy. The sacrifice that I spend in time, inconvenience, and discomfort, I mean, definitely putting himself out to be a martyr. But if you aren't doing it, if you aren't having fun, you aren't doing it right. Doing it because he's having fun. And then it goes further. In that April 25th, 2019 letter, it wasn't just about this
I'm
alleged...
sorry, I gotta stop. He's not supposed to be like this. He's
No, I
trying
would
to
ask-
taunt me.
Stop.
He's trying to
Kim!
taunt me, Judge.
Stop.
Blandino?
No, I would ask, can you invite Mr. Dickerson to not approach the defense table? I'm sorry.
Okay.
If he can
Hey.
stay.
He's trying to taunt
Stop,
me, Judge,
Stop talking.
purposely. He knows he's trying to taunt me.
Stop.
This is
Well,
improper, and I'm making a bar
lawyers
complaint
are
against you.
permitted
Quiet.
I'm making a
walk
bar
around
complaint
the
against you,
room.
Mr. Dickerson.
Be quiet.
I will get these jabs,
Your Honor,
and I will make a bar complaint against you.
stop.
Mr. Blandino, stop.
If I would have done this, you would have told me immediately not to do that.
Completely and totally inappropriate.
It's inappropriate for him to come here multiple times, and you know that, Judge.
He's in the well. He is permitted to walk around the well.
You would not let me do that if I were representing myself.
Stop.
If I were going over to the prosecution.
I'm sorry. Look, I was just asking, Your Honor,
Okay,
he can be,
we're gonna
if he
take a
doesn't,
recess. During
I-
this recess, you're
I can
allowed
stay.
not to discuss or communicate with anyone, including your fellow jurors, in any way regarding the case or its merits, either by voice, phone, email, text, internet, or other means of communication, or social media, read, watch, or listen to any news or media accounts or commentary about the case, doing research, such as consulting dictionaries, using the internet, or using reference materials, make any investigation, test a theory of the case, recreate any aspect of the case, or in any other way investigate or learn about the case on your own, or form or express any opinion regarding the case till it's finally submitted to you. We'll be in recess, and Officer Ox will let you know when we're ready.
Thank you. All rights for the next jurors, please. Jurors?
Mr. Blandino, it is completely and totally inappropriate for you to lash out and scream at the prosecutor while he's doing his closing argument. Totally inappropriate. If you don't like something, tell your
I told my
attorney,
attorney 3
and
times
he
that
will
he cannot do that, he should
and
have
you will
kept.
raise it with the court,
He did not,
okay?
and I had
He's
to
in
raise
the
it, Judge.
well. He can walk around in the well if he wants to.
When I
Okay,
had
I'm
my
not
stu-
sure
when
what
I had my
else-
trial in the 1990s, I tried to walk
Okay.
around and Judge Moppin, he said, you can't walk around, you gotta stand at the table. And you wouldn't have, if I were representing myself, you would not allow me to go over to the prosecution table. I know that for a fact, and if you're in your heart, you ask
Stop.
get the truth,
Stop
you'd say that's
pointing at
true.
me.
You know that's true.
Stop shouting at me.
I'm sorry. I'm a little bit heated, I
No, you're
apologize.
completely and totally out of control. It's not
No.
heated, it is completely and totally out of control. Okay, I'd like to bring the jury back in so Mr. Dickerson can conclude his closing.
If he
Can
would,
you control yourself? Because if not, I'll just
I
remove you
will,
from the
I will,
courtroom.
I'm sorry, I apologize, but if he can agree not to come over here to
No,
the
he
table.
doesn't have to agree with you about
He said he
anything.
would just a minute ago.
He doesn't have to agree with you about anything. If you can't control yourself, you will be taken out of the courtroom
Okay, I
so that the
apologize.
prosecutor can conclude
I
with his
apologize.
closing.
I apologize.
Can
I'm
you
sorry.
control yourself?
Yes.
Okay.
you know, if I just may, he's saying that I wouldn't make the objection. The third time he came over, he said, you know, I don't know what he did, he was turning or whatever to Mr. Dickerson, asked me to say, you asked him not to come over here, I was going to object or ask Your Honor to have him not approach the defense table because he can't seem to control himself and he was turning. So, I was not, and then he just started looking. So I was intending to ask Your Honor if he could not approach the defense table when this was,
I've never
whatever
seen
this
it.
was happened.
I've never seen anything like this. This is just completely and totally inappropriate. He's in the well. I mean, you can't control
Why
yourself.
wasn't I told about that?
Because the district attorney is walking around giving his closing argument.
Why is he getting that close to the table,
Like I
Judge?
said, if you cannot control yourself, you will be taken out of the courtroom so Mr. Dickerson can conclude. Do you understand what's gonna happen? You can't scream at people in the courtroom.
That's my normal voice.
It's screaming.
I can't whisper,
Okay, that's a normal voice right there.
yeah, I'm kinda
Okay,
trying
when
to
you
keep it
start
calm.
screaming at people in the middle of their closing argument, it's totally inappropriate. You realize the jury just saw what you did?
I know they saw that.
That's not good for you. I'm just here to tell you.
I know that.
That is not good for you.
That's why he was taunting me.
So
He
you-
wanted a reaction. He wanted a
So
reaction,
Mr.
and he got it.
Dickerson owns you? Okay.
No, he
So
wanted
his
to do it.
behavior dictates how you
That
behave.
was taunting.
Okay,
That was
he was
taunting.
not taunting you. That is ridiculous.
No, it is not.
Can you control yourself so I can bring the
Yes, I
jury
can.
back in?
I can.
Okay, have a seat.
Thank you.
You can bring the jury back in.
I think Mr. Bateman,
Stop talking.
It's gonna be a moment, ma'am. There's two of them in the restroom.
Okay, no problem.
Don't say anything.
can I apologize to the court again? He was taunting me, and I felt for this. I guess he got what he wanted. He got what he wanted. He wanted an outburst, and Dickerson, he wanted it.
I know Mr. Dickerson very well. He was not taunting you.
Oh, he knew that there was a possibility of me blowing, and he got what he wanted.
How would he know
How is
that?
it
I mean,
proposed?
that is, it's just,
Because he studied me. This guy is an expert on studying people.
Judges,
what?
judges see me do so many closing arguments.
Yes, I
The
have.
same way. And against really violent people that have really hurt people, and nobody's ever done it.
Thank you, everyone, please be seated.
Does the state stipulate to the presence of the jury panel?
We do, Your Honor, thank you very much.
Mr. Bateman?
Yes, Your Honor.
Okay, Mr. Dickerson, you may continue.
Where did we leave off? April 25th, 2019 letter. This was, in addition, at this point in time, he writes, I believe you should seriously consider resigning. Not, I believe that we should sit down and have a talk. And I just want an apology. He goes on, we should meet to see if we can, we should meet and see if these matters can be settled for all concerned and for a multitude of reasons as cited in part above. Please know that you will be judged as you have judged. Right there too. The meeting is not about just a meeting. The meeting is coerced. It's coerced by the withholding of filing complaints, by the withholding of the disgrace that he intends, that Mr. Blandino intends to impute upon Mr. Federico. And so, that's April 25th, 2019, and he's already said all that. It's already become so clear that everything defense counsel said about, he just, wanted to sit down and talk, and he just wanted, he just wanted an apology. Well, by that point in time, when you're asking for an apology under a coercive threat, that's extortion. But we know that's not all he wanted. We know that Mr. Blandino wanted much more than just an apology, because on April 29th, 2019, when Mr. Federico called him and just said, what's it going to take to get you out of my hair? Mr. Blandino could have just said, oh man, I just wanted an apology, right? Though he's already committed extortion by this point in time, that's not what he said. When given the open-ended question of what's it going to take to get you out of my hair, Mr. Blandino says, at minimum, it's going to require an apology in a public forum. And the other things, I'm going to have to think about those. I'm going to have to take some time to think about it, and I'll get back to you. Because there were always other things. How far can he take this? Mr. Blandino, how far could you take it? Well, that's why we know. We look at this defense that Mr. Blandino has proffered, entrapment. This is an affirmative defense where he bears the burden of producing evidence of governmental instigation. The government hasn't instigated Mr. Blandino to do anything. All of his actions here today, his actions there on April 8th, 2019, on April 25th, 2019, on April 29th, 2019, on May 2nd and May 3rd, and May 16th, and May 9th, 2019. All of those were his own actions. Just as much as him jumping up in the courtroom today and yelling were his own actions.
I spilled water on myself. I'm sorry.
And so we look at that. Defendant bears the burden of producing evidence of governmental instigation. They have not shown governmental instigation. Nonetheless, the only way that you even reach the other considerations under entrapment are if you find, yeah, it appears that Mr. Blandino has shown governmental instigation. Well, that doesn't exist. We'll still talk about the other part. So once Mr. Blandino puts forth evidence of governmental instigation, the state bears the burden of proving beyond a reasonable doubt that the defendant was predisposed to commit the crime. And then the law provides you a number of things that you can consider, but it's not everything, because you can consider literally everything that you've heard. All the evidence. Everything that you know to be true, and everything that you can make a reasonable inference about. Including the character of the defendant. Who first suggested the criminal activity? We just went through that. It was Mr. Blandino himself. Whether the defendant engaged in the activity for profit, well, he was getting $25, whether it was to pay a debt that he owed or to go into his pocket. Either way, yes, it was for his own profit. Whether the defendant demonstrated any reluctance, zero reluctance. Zero reluctance. Mr. Blandino never demonstrated any reluctance because Mr. Blandino did all of this deliberately. He set out on this path. He set out on this path because this is what he does. And that goes back to the first one, his character. What is Mr. Blandino's character? Mr. Blandino is a man who does this by his own admission, by his admission on the stand, by everything in his letters. This is what he does. And if you're not having fun, you aren't doing it right. That's the kind of character that Mr. Blandino is. And the nature of the government's inducement. Let's talk about that. The nature of the government's inducement was a call saying, what's it going to take to get you out of my hair? You heard. There was no offer to pay Mr. Blandino. There was no offer to do an apology in writing by a judge, acknowledging that Mr. Blandino has a right to go and view all courtroom proceedings anywhere he wants. There was no offer to have Mr. Federico, in his capacity as a pro tem judge, go take a judge class at the Judicial College in Reno. There was no offer for Mr. Federico to pay $500 to the Clark County Law Library. None of that. There was no inducement. The inducement, if they want to have anything to argue, is nothing more than a phone conversation. There was nothing more to offer there. This was all Mr. Blandino's own doing. And the most important factor, the law goes back, is whether defendant demonstrated reluctance, which was overcome by the government's inducement. Again, that's the most important factor, and there was zero reluctance. How do we know that? Well, other than all the evidence, what did Mr. Blandino sound like on that call? Giddy is how it was described by witnesses, but by Mr. Blandino's own account of that call, he was happy and surprised. There's no entrapment here. So that call goes on. Mr. Blandino has the opportunity to think about what he wants, and he takes days drafting the document that he ultimately sends over on May 2nd, where he indicates, as you've seen over and over in this document, to Mr. Federico, right, in his capacity as a pro tem judge, what he wants is what we just talked about, and what we've talked about this whole trial. $25 in his pocket, an apology in writing with an acknowledgement that he can go and view any of these courtroom proceedings, $500 to the Clark County Law Library, or going up to Reno for several days to take a class, a judge class at your own expense. That is action by Mr. Federico in his capacity as a judge. So, influencing the actions of a public officer is what Mr. Blandino set out to do. That's his intent the whole time. That's his intent with everything he does. When he contacts these judges, when he sends these letters, all he wants to do is influence the actions of judges. That is what his intent is. And by sending all of these correspondence to Mr. Federico in his capacity as a pro tem judge, his intent to do that with Mr. Federico is clear. This was not his intent to influence Mr. Federico in his capacity as a private civil lawyer, as a dad of 6 kids, as just some guy. No, he made it clear. His intent was to influence his actions as a judge. And point in case, beyond just what we see in all these documents, one of the things that he wanted him to do was go take a class for judges at the Judicial College. This is something that a judge does. That's it. He's influencing his actions in his capacity as a judge. That's what he intends to do. And what he's threatening to do is clearly not file the complaints with the Commission on Judicial Discipline. So, at this point in time, that's the only real threat, is not to file the complaints with the Commission on Judicial Discipline. But after that is when it starts to ramp up, right? Again, now Mr. Blandino has seen that he's getting somewhere, or at least feels that way, and he was just starting to have fun. So let's play some more and see what we can do. So he ramps it up. He ramps it up by responding to the email that Mr. Federico sent on May 9th with the letter that Mr. Blandino had been preparing for days, 2 days approximately, the letter of May 8th. It's in this letter, the letter of May 8th, where Mr. Blandino indicates, I spent a great deal of very valuable time preparing that document. I will need an answer or for you to otherwise respond to this proposed settlement on or before May 23rd, 2019. I do appreciate the call, he says. I'm doing this more for people that follow me, he insists. Now, he goes on. He calls it in this letter what he's offering, Mr. Federico, what he's offering not to do. Not file those judicial complaints as something very serious, as he indicates it. Something very serious. And he then goes on, and this is where he ramps it up. In fact, you can be criminally prosecuted for a misdemeanor violation of federal civil rights under 18 U.S.C. Section 242 for your actions on April 25th, 2019. So it wasn't until after he'd already sent his first iteration of what he wanted that he has to put on more pressure. And he has to say, well, obviously Mr. Federico's not getting the message, so I need to pressure him further. Up until this point in time, Mr. Blandino had not threatened to accuse Mr. Federico of a crime. But he goes on in this letter and decides, well, we got to do that because what else am I going to threaten him with at this point in time? What else is going to get him to act? What else is going to get him to engage with me? Because he says, I have already told you that if we cannot settle this matter, I'll file a complaint with the Nevada Commission on Judicial Discipline. But then he goes on, if we cannot come to a settlement, I believe it would be proper to go to the FBI with a criminal complaint against you for stopping me from observing you on the bench on April 25th, 2019, which he indicates is a violation of 18 U.S.C. 242, a civil rights violation in his mind. But that's not it. That's not all that he's now ramping it up to threaten. He's now adding in additional threats. Additionally, he indicates, I have come to realize you work with a partnership titled Olson, Cannon, Gormley, Angulo, and Staberski, that I should give notice to these individuals of the matters involved prior to filing with the Nevada Commission on Judicial Discipline or the FBI. And then he tells all of us exactly what he's thinking. The calculus is simple. Putting myself in place of any one of these partners and everything else equal, I would want to know that a person who worked with the firm and had a prominent web page was not bringing any disrepute in any way to the firm or its name. Because, he indicates, these issues could affect how the firm is viewed in the public. And then he goes on, therefore, consistent with my beliefs, I will send a copy of all the relevant documents to Olson, Cannon, Gormley, Angulo, and Staberski unless I hear from you by May 15th, 2019. Extortion again. Unless I hear from you, Mr. Federico, in your capacity as a pro tem judge, influencing the actions of a public officer, he will expose him to disgrace by sending all of this stuff to the partners of his firm. Well, we all know what happened. Mr. Blandino didn't get what he wanted. He didn't get what he wanted. He didn't get it the next day, and he didn't get it on May 15th. And so he made good on one of his threats when on May 16th, 2019, he sent that email with all the attachments, every single thing that had so far been sent to Mr. Federico, to the partners of the firm. And in there, he pressures the partners of the firm to sit down with Mr. Federico so that these things don't become public, right? He says, I'll need a response within 1 week. He says, he also indicates there that since I gave Mr. Federico till May 23rd to settle before filing a complaint, I gave a deadline of May 15th to at least begin good faith negotiations, or I will notify the firm so that the firm has a heads up. If Mr. Federico failed to inform the firm of the situation, he might be required to do so. And I've attached all my prior submissions, he says, knowing that this would bring disrepute, that this would humiliate Mr. Federico, and so he did it. And the whole time, in his mind, he was doing it right because he was having fun. Mr. Blandino does not care what the law is. He does not care what he is allowed to do by law. He only cares what he can try to get other people to do, because that is fun for him. He wants to control my closing argument in this courtroom today. He wants to control Mr. Federico the same way. These are his actions, all of them. None of this is government instigation. All of this is Kim Blandino. And because of that, ladies and gentlemen, because of everything that he did in this case, the multiple ways that he has committed extortion, we are asking you to find him guilty of but one count of extortion. Though there are several extortionate matters here, we only ask you to find him guilty of the one count that he's charged with, which encompasses everything. Further, it's clear. It's clear that he's been holding himself out as an investigator for the Nevada Commission on Judicial Discipline. He does that so that he could have an air of authority. The investigators for the Nevada Commission on Judicial Discipline, well, it was argued by defense counsel that they're not public officers. You have an instruction on that. Instruction number 17. It indicates by law, they're required to have investigators. Further, that these investigators have the ability to compel evidence and compel witnesses. They have the authority to employ and contract with investigators. Nevada Commission on Judicial Discipline investigators have legal authority to compel by subpoena the attendance of witnesses and the production of evidence. Jury instruction number 15 tells you what a public officer is. Clearly, investigators for the Commission on Judicial Discipline are public officers. That's what he's pretending to be. They argued further as it goes to the impersonation of a public officer that Mr. Federico was not injured. Just because Mr. Blandino laughs at Mr. Federico's anguish, his worry, his concern, the concern for his family, the fact that he started carrying a firearm, the fact that he started worrying about his kids' bus routes, just because he laughs at that and he doesn't think it's something, it is. He's injured. That's the bottom line. And the action which he did to cause that injury was extortion. He's doing all of it under the guise of being an investigator for the Commission on Judicial Discipline. Somebody that could harm his career. That's it. He's guilty of that crime too. And so, ladies and gentlemen, you take a look at the evidence, you've seen it. What it mostly consists of are the defendant telling you exactly what he was doing. And we know he was trying to have fun. He was trying to have fun by influencing the actions of a public officer like he has so many times and doing it by threat. So today, please show Mr. Blandino that this is not okay. This is illegal. And it's time that he be held accountable. When you go back to that jury deliberation room, I ask you to come out and tell Mr. Blandino that he's guilty. Guilty of extortion and guilty of impersonation of a public officer. Thank you.
Okay, at this time, the clerk will swear the officers of the court who will take charge of the jury panel.
You do solemnly swear that you will keep this jury together in some private and convenient place, that you will not permit any person to speak to them, nor speak to them yourself, unless it be by order of the court, except to ask them whether they have agreed upon a verdict, and you will return them into court when they have so agreed. So help you God?
Yes.
Okay, thank you. At this time, Ms. You have been selected to be our alternate juror, so I am going to allow you to leave the courthouse if you want to. You will not be required to stay here during deliberations. However, I'm going to ask that you see Ms. Osterman before you leave. She's going to take charge of your notebook, your badge. She's also going to get your phone number. I just ask that you don't go further than 45 minutes from the courthouse. So if we need you to come back for whatever reason, we can get you back here in a timely manner. We will contact you and let you know either you have to come back or that you have been discharged as a juror. And I just want to remind you that you're still under the admonition not to discuss this case with anyone. So you can go see Ms. Osterman. She's going to meet you right out there. Ladies and gentlemen, the jury, you can pick up your notebooks, your instructions, and take all your things. And Officer Hawks will take you back to deliberate upon your verdict.
Thank you, all right. All right, Vaccine very good. All right, for entering jury. go ahead and be seated when you get to your chairs.
Thank you, sir.
Please come to order. Court is now in session.
Does the state stipulate to the presence of the jury panel
We do, Your Honor.
and the defense?
Yes, Your Honor.
Thank you.
Thank you, everyone. Please be seated.
Mr. Romero, have you been selected to be foreperson?
Yes, Your Honor.
Has the jury reached a verdict?
Yes, Your Honor.
Will you please hand the verdict form to Officer Hawks? Okay, the clerk will now read the verdict out loud. If the defendant and his attorney will please stand for the reading of the verdict.
District Court, Clark County, Nevada, State of Nevada, plaintiff versus Kim Dennis Blandino, defendant, case number C341767, Department number 12, verdict. We, the jury, in the above entitled case, find the defendant, Kim Dennis Blandino, as follows. Count 1, extortion, guilty of extortion. Count 2, impersonation of an officer, guilty of impersonation of an officer. Dated this 9th day of March 2022, signed by foreperson. Ladies and gentlemen of the jury, is this your verdict is read? So say you one, so say you all.
Okay, does either side wish to have the jury panel polled? Mr. Dickerson?
No, Your Honor.
Mr. Bateman?
I don't normally do this, but yes, Judge, I would ask you to.
Absolutely. At this time, ladies and gentlemen, the clerk is going to ask you a question, and I just ask you to respond yes or no.
Juror number 1, is this your verdict is read?
Yes.
Juror number 2, is this your verdict is read?
Yes.
Juror number 3, is this your verdict is read?
Yes.
Juror number 4, is this your verdict is read?
Yes.
Juror number 5, is this your verdict is read?
Yes.
I'm sorry, it's going to be Miss, or I don't want to say your name. Thank you. Juror number 6, excuse me, is this your verdict is read?
Yes.
Juror number 7, is this your verdict is read?
Yes.
Juror number 8, is this your verdict is read?
Yes.
Juror number 9, is this your verdict is read?
Yes.
Juror number 10, is this your verdict is read?
Yes.
Juror number 11, is this your verdict is read?
Yes.
Juror number 12, is this your verdict is read?
Yes.
Okay, at this time, the clerk will record the verdict in the official record of the court. And at this time, ladies and gentlemen, you can have a seat. I am going to discharge you from your duty as jurors. You are no longer under the admonition not to discuss this case with anyone. You're free to discuss it with whomever you want. However, you're under no obligation to discuss it with anyone. I am going to excuse you to go back in the jury deliberation room where you will get further instructions. And then you will be excused to go. I do always like to give the attorneys for both sides the opportunity to talk to the jury panel, but only if you want to. Both sides do try cases a lot in this courthouse, and I do think it's good for them to speak to a jury panel afterwards to see what you liked and didn't like. I think it makes them better trial attorneys. However, it's completely up to you whether you want to talk to either side. But before I do excuse you, I just want to extend my gratitude to you for your willingness to be here. Especially, we went a couple extra days than what I had told you, and I want to thank you very much. You were very courteous and you were very professional, and I really appreciate it. So at this time, ladies and gentlemen, you are discharged as jurors.
Thank you. All rise for the next jury. Jurors, if you'll please go with Ms. Osterman. Thank you, everyone. Please be seated.
Okay, the record reflects that the hearing is taking place outside the presence of the jury panel. Mr. Dickerson, do you want to be heard?
We would like to be heard, Your Honor. At this point in time, the presumption of innocence is gone. Mr. Blandino has been found guilty by a jury of his peers. He's no longer entitled to bail. We would ask that he be remanded today on these charges awaiting sentencing.
And Your Honor, we would ask that you allow him to remain on his bail and allow him to, on bail and his ankle bracelet, the electronic monitoring. He is local here to Las Vegas. He is not a flight risk. He is the caretaker for Ms. Pendergraft, who is present in the courtroom here today. I think that he certainly needs an opportunity, if he, awaiting sentencing, to be prepared and to have any affairs in order that would need to be in order for a sentencing date. But again, he is not a flight risk. He has been, I don't know that he has had any issues on being on the electronic monitoring. I believe that he is on medium level, if Your Honor would feel more comfortable perhaps putting him on the high level electronic monitoring, and that he would be here. He's not going to miss any court date, and like I said, he's not a flight risk. He wants to come to court. Mr. Dickerson alluded that this is fun for him, and so I don't know what else to say. He's not a flight risk. He's not going to miss any court. He has been, and on the electronic monitoring, you know where he's at. He's not any threat or danger to the community. He hasn't been for the 2.5 years he's been on.
If I may.
Just wanted to make sure Mr. Bateman.
Yes, he wanted, I did forget, he did have the 2-week absence in December where he went, you allowed him to travel to his son's graduation, where he was off the ankle bracelet. No issues coming back, getting back on the electronic monitoring ankle bracelet. So I think all that demonstrates that he is, I think, a good candidate to remain on his electronic monitoring and will be here at any future court dates.
The state of Nevada has to disagree. We have to disagree about him being in a position at this point in time where he wants to come back to court, him being in a position where he's still having fun. Mr. Blandino's no longer having fun. Mr. Blandino's no longer in control of the situation. We've seen throughout this case what Mr. Blandino does when he's not in control or he feels like he's losing control. He obstructs, he refuses to cooperate, including when he was ordered to get tested, psychological testing through Lakes Crossing, before Lakes Crossing for that matter, Your Honor, by this court. He refused to cooperate with that. He then was forced to be remanded and sent to have those evaluations done because of his obstruction and refusal. Then throughout this case, off the top of my head, I believe it's 22 motions to disqualify the courts that were solely for the purpose of obstructing and harassing these proceedings whenever he was feeling like he was no longer in control of things weren't going his way. It's clear. Today, he's been found guilty. Things are no longer going his way. He should be remanded. He is a danger to the community in the fact that we've seen his behavior here in court. We've seen his disrespect for the law. Mr. Blandino does not respect the letter of the law at all. He doesn't respect court orders. He's violated this court's orders in the past. He's violated past court orders, even indicating in some paperwork that he was going to go do surveillance at the named victim's residence in this case. That is incredibly concerning to the state. I would also note that he is a convicted felon. In that particular case, which is also of concern, he fled the state of Nevada with his children that he kidnapped, changed their names, told them that their mother had spiritual cancer and that she died. This is an individual who has extreme issues. He needs to be remanded pending sentencing, and I think that the state of Nevada will be in a good position to also, at some point in time, request some litigation regarding evaluations prior to sentencing as to his mental state and what should be happening with him at the time of sentencing.
If I may speak to the, sit down. Okay, please.
Sorry.
As to the, I was standby counsel at that point. That was in competency court. Honestly, there was a discrepancy and a misunderstanding as to whether the appointment had to be set or the evaluation had to be done by the date certain. Mr. Blandino is not well liked. He does not get the benefit of the doubt. And I'm not a witness, but he did set the appointment. He did not have it. As far as disobeying the orders for his evaluations. This was in December around the holidays. He was not when that happened. So I don't think that is what happened, that he was willfully disobeying those orders to be evaluated. Like I said, it was difficult at that time to get appointments. He did set appointments. And so as far as that is concerned, I don't think that should be counted against Mr. Blandino for disobeying the court. We heard testimony, Judge, from the detective after doing the search warrant that there was nothing that indicated he was a threat or a danger that led to additional charges and all those papers and all those files or anything like that, that Mr. Blandino was a threat. So I think he, if he's on the high-level electronic monitoring program and he's on bail, so he's got he's got the jail who runs the electronic monitoring program, he's got private bail company with their bounty hunters. He is not a flight risk. He is not a danger. The high-level monitoring, I mean, they have strict curfews. They have strict rules about when he can go, where he can go. Since he doesn't, I don't think he doesn't have a 9-to-5 job, is what I'm trying to say. So he can't really go anywhere during the day. And also, as far as filing, obviously, he's a vexatious litigant. He can't file. When I was standby counsel, my understanding of my role was that, he was the attorney and I filed these things. Obviously, I've said it before. Clearly, I filed things as standby counsel that I would never file as an attorney. So I don't think that that's an issue of him filing anything here with the court. So, because that would go through me, I will not file anything that would be, I can't imagine anything that I would need to file, but certainly none of the sorts of things like along the lines of what was filed, the motions to disqualify, or any of those things, I will not file that or anything like it. So I don't think that's a concern either.
I would note one thing regarding it being brought up that the detective testified that there's nothing of concern found during the search warrant. The detective clearly didn't want to get into all the other things that have been found during the investigation, which could be unduly prejudicial. But that includes the fact that Mr. Blandino, even after he was charged in this case, continued this same behavior, including to the Justice Court Pro Tem Judge, Talia Williams, who sat on his case in this same case in Justice Court before he was indicted, where later on, after his indictment, he sent her the letter that we discussed in the hearing outside the presence of the jury in November of 2019, indicating that she needed to recuse herself from a civil case that was before the Justice Court that he believed that she was a judge of, and that if she didn't recuse herself, he was going to be filing complaints against her with the Nevada Commission on Judicial Discipline. That letter, too, he took up to her private law office and dropped it off. His criminal behavior has continued, Your Honor, and it's time to put it to an end.
Was he a party to the civil action?
He believed that he could be an intervener in it, but at the time, he was not.
So he was not a party.
He was not a party.
Okay, I'm not, I guess I can't speak to that, to civil matter. I'm not able to speak to that. I don't know about it.
Can I say anything?
No.
Okay.
No, you're represented by counsel. So at this time, I'm going to allow him to stay at liberty pending sentencing. His monitoring will be raised to high level electronic monitoring. All of your conditions will remain the same. So you understand you're not permitted to have any contact with the victims in this matter.
Correct.
And you're not permitted to send any letters of the kind that you, in this underlying matter.
Can
Do
I
you
continue to
understand that?
file complaints with the Commission on Judicial Discipline though? And they'll do the ordinary course?
I would ask that anything that he's going to file, any complaints or anything like that, should go through his attorney, Your Honor. At this point in time, we know that he's
That's
using.
a very good idea.
So I send them to him and then he clears it?
That's correct.
Okay.
Right, and then you won't have any issues. Because if you have any issues pending sentencing, you will be remanded pending sentencing.
Okay, understood.
Do you have any questions about what your conditions are?
Stay away from Nordstrom, stay away from Federico. No filing commission on judicial discipline for complaints except for him. Now, I do
No
want,
sending people
okay, now,
letters.
one thing I do have to, I tried to file, or serve Mr. Federico, and my son tried to. I gave it to legal wings this morning, because I didn't know if I was gonna rename it, so a third party will be serving Federico with that federal civil rights suit. And as you know, we're supposed to try and negotiate, or try to resolve it without going through the trial, so how do I handle that?
Have any contact with Mr. Federico.
Well, how do I handle that with the federal court?
Do not have any contact with
Okay.
Mr. Federico.
So if I had,
Okay, I
So
mean, I
even-
just wanna make sure, I don't care what litigation you have going on, you get an attorney, you get
so if
somebody
I
else
get an
to have
attorney
the
and contact through the attorney, it's okay.
That would be fine,
Okay,
but you cannot have any direct contact. He clearly does not wanna have any contact with you.
well, yeah, but I'm not allowed to file a federal civil rights suit, and that's what I
You
did.
sure?
Yeah.
So with that, we would also request, since you're gonna be leaving Mr. Blandino out of custody, we request an overall order that he not be at the RJC or the property of the RJC unless he's here for a case where he is a party for an actual court appearance and during that time. We also wanted specifically that he not come to any of the offices of the Clark County District Attorney's Office. During the course of this case, it's come to my attention that Mr. Blandino has visited our reception at the Clark County District Attorney's Office, caused the women working there to feel very uncomfortable, started yelling at people in the lobby or harassing
That's
people in the
not
lobby
true.
Hey,
about
stop.
wearing, as he calls them, diapers on their face because they're wearing masks. It's something that is of concern to our office, and our investigators are aware of it. He is not allowed at the district attorney's office as far as we're concerned, and I've told him that he's trespassed.
Okay, do you understand that? You are not permitted to come to the RJC for
Right.
any reason unless you have a proceeding here where you are the party.
Now, does that
Do you
include
understand
if I have to go to the clerk's office because the computers are down to file something or that, how do I do that? I have to mail it?
You're just trying to talk me out of letting you stay at
No, I
Liberty,
just
aren't you?
wondered,
Yes.
I just
Quiet.
wondered.
Yeah.
I mean, I
Be
literally
quiet.
feel like you're trying to talk me out of allowing you to stay at Liberty.
Okay, no, I appreciate it.
Yeah. Just some clarification, with whom do I, if he has a complaint that he sends to me, with whom am I supposed to clear that? With Your Honor, with Mr. Dickerson? I just want a little.
No, you use your discretion.
Okay, perfect.
Yeah, I mean, you're an attorney, you're
Yes,
an
okay, I
officer of
just,
the
I
court.
wanted to make sure that that's what the
Absolutely, so the
the
matter,
criteria was.
the
Okay.
matter will be referred to parole and probation. You understand you're gonna be required to go to parole and probation. You're gonna be required to participate in an interview. Do not let that report come back to me saying you refuse to participate.
What do you mean for the PSI report?
That's
But
correct.
I go to the jail for the upgrade on the high level though.
That is correct.
So it's two separate things I'm doing, parallel
That's
paths,
correct.
okay? All right.
But again, I just wanna make sure you understand you have to go to parole and
Do you have a
probation.
report date for me?
I have paperwork for you. just
Oh,
let
okay.
Judge finish.
My suggestion is you go within the next 48 hours.
Oh, that's no problem there.
So that they can make sure they get it done, the interview, and prepare the report and get it to the court on time.
Yeah, do I have to make an appointment with them or can I just drop in? I don't know.
You're gonna be given paperwork, just.
Oh, okay.
I
Let the
believe you
judge
can
finish.
just report to PNP. I don't think you have to make an appointment,
Ah, okay.
okay?
Sentencing is going to be July 7th at 8:30. If we're still on pandemic schedule, that will be at 12 p.m. And Marshall, here's paperwork to be placed on high level. Oh, and
I'm sorry, Madam Clerk, what was, so it was July 7th?
Yep, July 7th at 8:30. If we're still on
Oh.
pandemic schedule, that'll be at 12 p.m.
One thing slipped my mind, and it's the fact that the municipal court, which has been the target of much of Mr. Blandino's ire, has now moved to a different building. And so we would also request that the stay away order include the municipal court, Your Honor, unless he has the same thing, a case that is on calendar that day at the court.
I don't perceive that's out of line.
Okay, so I'm gonna include, I mean, because the Las Vegas Municipal Court, they used to be in this building, now they have their own. So you understand you can't go into that building
Okay, yes.
unless you have a case on calendar wherein you are the party.
Okay,
Do you
yes.
understand that?
Yes, I do. Thank you.
Okay.
I want to, this might be premature, but I just want to say that
or to put the defendant on notice. I do not do appeals, I do not do appellate work. Mr. Blandino has filed things alleging and about my ineffectiveness, and so obviously I'm sure that would, if an appeal were to come of this, that would be an issue, and I will not be handling that appeal. Mr. Blandino, quite frankly, probably has more experience with appeals than I do. But I would like to put him at least on notice now, I will not be handling any appeal, I will not be filing any notice of appeals on his behalf.
Okay, so it sounds like Mr. Bateman's gonna ask to withdraw as your attorney of record after your sentencing.
Right.
So you understand you have 30 days to file a notice of appeal?
Well, after a judgment of conviction with a sentence, I can't appeal until the judgment.
Just-
That's correct.
Right.
That is correct.
Although they allow a early thing.
So, if you want Mr. Bateman to help you with the notice of appeal, he may, but I'm assuming you're gonna wanna represent yourself on appeal.
Well, they're under Blandino versus State, which is named after me.
Is
I
that a
cannot-
yes? Okay, I'll take that as a yes. Okay,
Yes.
anything else?
Thank you, Judge.
No, you're
Thank
Appreciate it.
you.
Thank you. Court is now in recess.